So we're going to discuss marital separation agreements. We only have a short time, an hour. So we're going to basically touch on different parts of the separation agreement. But just so you know that there's a lot of nuances and things that you would really need to know and really discuss with an attorney with more complicated cases. So the first question that I get a lot is, well, what is a marital separation agreement? Now, a marital separation agreement, it's a contract between you and your spouse, okay? You have to be married to have a marital separation agreement, of course, where if you wanted to do an agreement between you and your partner, you're not married, and let's just say you were dealing with custody or child support, that would be called a stipulation of settlement. If you were arguing over with you and your partner, you both had a house together and you were splitting up, that would be a contract, a real estate contract between yourself and your partner. So this deals with two individuals who are married. So the first thing that is being a contract is you have to realize that I cannot force you to sign it. The other party cannot force the other party to sign it. It has to be done through negotiation and mutual understanding. Now, a lot of people have this misconception that this is a binding document, and you can go to court and say that, well, we have this agreement, it's a marital separation agreement. It's really, you'd have to go to court and it would be under a contract proceeding. And what does that mean? So if you sign an agreement, remember it's a contract between you and your spouse. It is not a court order. You can't hold someone in contempt for violating this marital separation agreement because, again, it is not a court order. If you both were to sign this agreement, and that's after you negotiate the settlement, the only way to enforce this would be, number one, go ahead and file for divorce and ask the Supreme Court to make the marital separation agreement a part of the divorce proceeding. Or secondly, if you don't want to commence your divorce proceeding, you would have to sue them under contract theory. So what do I mean by that? So in this separation agreement, I was supposed to give my spouse one half of my bank account within 30 days of signing this agreement. I don't do it. What's the remedy for my spouse? Depending on the value, you could either go to small claims court to enforce the contract, or you can go ahead and if it's a larger amount of money, go to Supreme Court and try to enforce this contract. All right, now contract principles would then apply to this separation agreement, not domestic relational law, not family court issues, not family court law, not any equitable distribution would not deal with these issues. You look at contract law. So let's just say then we go ahead and we enter into an agreement. And what's the next step? So both parties agree, negotiation. And the next step would be both parties sign it. It has to be notarized. If it is not notarized, it is not a legal document. Also, when you move forward with a separation agreement, you should file it with the county clerk's office. Is that anything that is going to stop this from being valid? No, it's not. So then the next step, people would say to me, well, geez, why do I want to get a divorce? You know, can I be separated? You can be separated as long as you want to be separated. Okay, there's no turnaround time to file a divorce once you're legally separated. But then again, like I said, you're both bound to comply with the contents of this agreement under the contract theory. Now, can separation agreements be modified prior to a divorce? or during a divorce? Yes, they can. But once again, it has to be mutually agreed upon, and it has to be in writing and signed by both parties. Now, when you move forward with a separation agreement, why would people ask, well, why would people stay separated? Well, the biggest reason to stay separated is, remember, you are separated, but you're still married. The one biggest reason that clients that I have that come to me stay separated is because of health insurance. If you're legally separated from your spouse and you are covering your spouse on health insurance, you can continue to cover your spouse on health insurance until such time as you're divorced. So some older individuals get separated, they divide up all their assets as far as the agreement sets forth under the contract, but they stay married for health insurance reasons. All right, so we have this agreement. What is part of it? What's in this agreement? So the first thing that we put into the agreement, the components of an agreement, are equitable distribution, and that's of assets, property, real estate, pensions, retirement accounts, 401ks. We also look at real estate, tax issues, how you're going to file your taxes. Then we also look at child custody, child support, and maintenance. Now, so we go ahead and we have an agreement and we set forth how we're going to divide assets. Now, what's very important, and when I tell clients that come in, is that do not, I'm going to tell everybody here, do not go online. Do not just look at something online, print it out, sign it, and think everything is done and everything is fine. It is not. New York State has become very complicated regarding case law and what the courts have decided what has to go in these agreements. Specific language, specific ways to divide assets. And if you leave any of these things out, it's going to come back to haunt you at a later date. Also, I tell clients, I do not recommend that you do a settlement agreement between yourselves and sign it without legal representation. There are times when clients will come to me and they'll say, well, okay, Mike, we want, my wife and I like a separation agreement. I say, okay. And then I say to them, is your spouse going to get an attorney? And they say, no, we want you both to do that. We want you to represent both of us. Cannot do it. If someone says to you that my attorney is going to represent both of us, and then that attorney speaks to both parties and tries to give them both legal advice, okay, the agreement most likely could be void based upon that because you're representing both parties and giving them both legal advice. So I do recommend that you both get attorneys. Now, if one party says, I'm not going to get an attorney, and I represent, say, the husband, and the wife says, I'm not going to get an attorney, I say to him, I'm not going to talk to your spouse. I'm not going to give her legal advice. You tell me what you want in this agreement. I'll prepare this agreement for you. I'm not going to discuss it with your wife. If you two discuss it, that's up to you. And then what will happen is that you'll have a final agreement for me. And then if for some reason your spouse, wife or husband, signs it without legal representation, that's their fault. All right. And for that spouse to come back later, if they don't like what's in the agreement, say, well, geez, I didn't have legal representation. In our agreements, we specifically set forth that other spouse knows they can get an attorney, that they have a right to get an attorney. They waive their right to an attorney, and they're going to be self-represented litigants. I have not seen any judge in my 30 years of practice overturn, for me, or that I heard of, overturn an agreement because the other spouse said, geez, I didn't have an attorney at that time, And it's set, and basically in our agreement says right there, you need to get an attorney recommended. It's basically almost too bad. They're gonna lose. Okay,
Mike, I have a quick question that
Yeah.
maybe some of the viewers have. You're saying that when we write the agreements, we put language in there to let everyone know if they review the agreement, that everyone had the opportunity to seek counsel. Would the agreement still not be overturned if the parties do something by mistake, like get the math wrong for maintenance or for the division of a certain asset, and find out the actual value was a lot greater than what they thought at the time of the agreement?
once, there's a case out of New York State, Saratoga County, about 10 years ago. The court is gonna look at the four corners of the document. So if this page on the four corners of the document says that both parties agree it was X value, and both parties agree that one spouse is getting this, and they don't do anything to verify what that value is, too bad, they lose. Okay, if it's so ambiguous, the court could then possibly look at it after looking at the four corners. When I say four corners, take a page, a paper, 1, 2, 3, 4, and whatever's in here in writing, they're gonna look at it, and it was just so ambiguous that there's no way that these people could have figured out what they were doing. They very well might take that and look at that agreement. That's far and few between that it ever happens. Okay? All right,
Thank you.
okay, sure. All right, so let's just go back and let's talk about equitable distribution. What is equitable distribution? Equitable distribution in New York, everyone thinks it's 50-50, but equitable distribution says fair and equal. Okay, now, I think I might have one or two cases where the parties didn't divide assets equally. Okay, now what do you mean by assets? So assets are anything acquired by the parties during the marriage, date of marriage, to the date of, let's just say, and working on this separation agreement. So let's just say a bank account. So parties are married, husband opens a bank account, and during that marriage, he puts a lot of money in that account. And then they decide to get a separation agreement. And basically at that point in time, the husband says, well, wait a second. That's my money that I earned during the marriage. Okay, so that's really my money because I put it in there. You got to remember that it doesn't matter who earns the money during the marriage, as long as it's marital funds that are acquired during the marriage, it's still split. So anyone that says, well, I put all the money in, so it's all mine, that's not true. Or someone says, well, geez, wait a second. We bought a house during the marriage and I paid the mortgage on that through the whole marriage. My spouse didn't pay anything. That should be mine. That is not true. Remember, marital money is 50-50. Now, when they say equitable, okay, not equal, usually in those type of cases, you're looking at situations with very high value separation agreements or clients. Okay, I mean millions of dollars of value. Okay, or if for some reason one party drags on a case for so long and or they fail to disclose assets or they hide certain things, then the court might go ahead and not make it equal but equitable to one of the other parties. So that's what you have to look at, but it's usually high value cases or cases where someone is deceptive or holds up the process to get the trial done. So we have a settlement agreement. So we put the information for equitable distribution. Equitable distribution would be bank accounts, retirement accounts, pensions, real estate, vehicles, personal property in the house. We could also look at equitable distribution. It could be
What about inheritance? If I inherit something during the marriage, that came from my family that's now deceased. Does my spouse have a right to some of that?
Well, we're talking about a separation agreement. We haven't got to the divorce proceeding yet.
Sure.
But in a separation agreement, if in the agreement, there is, say, there's a marital, let's just say there's a marital bank account of $50,000. Okay, and then they say, well, okay, we're going to split that equally between the two of us. And then one of the parties inherits a piece of property while they're still married. Okay, but we have a separation agreement. And if we look at gifts, inheritance, those type of things, is that part of the separation agreement? Well, it's not, because they've signed a separation agreement and it's not part of what they're supposed to do. Now, if they haven't signed a separation agreement and somebody inherits money, it really depends under matrimonial law what they do with it. So that would be the next step you'd have to look at when you get into a divorce proceeding. Do they inherit it during the divorce proceeding, inherit it while they're married? That usually, inheritance is considered separate property for the person who received that. So let's just say I inherited $1,000 and my father passed away, and then I took that $1,000, and let's just say we have a separation agreement, and I take that $1,000 and I put it into a separate account, and I don't commingle it, or I don't add it in with any other bank accounts or anything else. I just keep that in my name. That's considered my separate property when I get a divorce. Okay, same thing with gifts to you. Those are different things that would come up during divorce. Now, if I took that money and then we amended the separation agreement, and you can amend these agreements, all right, like we discussed, and then I said, we amend this, then we said, okay, well, we're going to include my inheritance from my dad as part of a marital asset. We're going to divide it up this way. Then basically, since we agreed upon it, it's no longer separate property. Okay. Now, when you look at these agreements, I'm talking about these different aspects. There are a lot of nuances when you talk about, let's just say, real estate. Now, and what you have to do with real estate, again, not only do you have to know what the equitable distribution law is in New York State and how these things are divided, all right? Because what you want to do in your separation agreement is fashion this agreement along the lines of equitable distribution in accordance with the New York State domestic relations law. That's what you try to do, all right? Now, for instance, you have a house. Did you own the house prior to the marriage? Did you put the other person's name on the deed? Who paid the mortgage? Is there anything in here? What are you going to do if you ever get divorced? Just like I said, so let's just say that I owned the house prior to the marriage. I bought the house 15 years ago. I get married. And then I put in this agreement that, husband and wife agree that the house is a marital asset, and we're going to sell the house and divide it equally. And we're going to split the equity. So one spouse is going to get $200,000, the other spouse $200,000, and you both sign the agreement. So then, and first off, if you're talking to an attorney, they should tell you that that's not the way you should do this. You would need to put in the agreement specifically what is separate property, what's marital property. Now, again, remember, in a separation agreement, you can agree on anything you want to agree upon. Of course, not as long as it's not illegal. But if I said, yeah, I want my spouse to have half of this, I don't care, I bought it prior. Okay, so you agree to it, or you put in there that, I'm going to get X amount, and my spouse will get X amount because I owned it premarital. Now, any good matrimonial attorney will go into detail regarding equitable distribution and how you divide these assets up. I've seen a number of separation agreements. Number one, where one party doesn't get an attorney. Secondly, that two people go online and draw up their own agreement. And then they come into me and they say, well, and I start explaining to them what the law is, and they look at me like they didn't know this. And then what you have to remember is that once you put your signature on this agreement, you're done. It's not going to change, with the exception of two things, which would be custody and child support. And Clark and I'll talk about that in a little while. But once you put in here that you're going to divide up the property a certain way, and this is how you're going to do it, that's going to happen. And the other party files for divorce, and they say, Mr. Judge, here's my marital settlement agreement. And the judge goes, well, Mr. Belsky, you agreed to give it to her. And then I said, well, gee, I didn't have an attorney. I didn't understand. I took something offline. They're going to go, too bad. You signed it. It's binding on you. It's not going to be overturned. So you're stuck. So lots of times you're giving away assets or not receiving assets the way you should be. And that's why you do need a separation settlement agreement. And I say an attorney to represent you. So you know what you're giving away. Not only that, in these type of agreements, what you're giving away, but on the other hand, with the spouses, what you should be getting. Okay, just don't believe your husband, your wife. And I'm going to tell you right now is don't go online and look online. And so many people come to me and say, well, I looked online and it says this. Or I spoke to my friend at the beauty parlor or the barber and they said, I should get this. Okay, well, don't believe what they say. Don't believe what you read online, because every case is different. They all have their own nuances. All right. And when you come and say that to me, basically, I tell you flat out that you're wrong, and I explain to them why they're wrong. Okay. Or just signing this agreement because I went online and said this is what should happen. Online's not an attorney. All right. You need to speak to somebody that knows what they're doing. Now, so we talked about equitable distribution. All right. The next thing, and like I said, equitable distribution also deals with pensions, retirement accounts. I could spend 3 hours talking about how to divide pensions and retirement accounts. Just so you know, there is numerous legal issues on how you have to put wording in an agreement to divide retirement accounts. And remember, we have pensions, we have 401ks, we have military retirement accounts, we have federal retirement accounts, and each one has to have certain language. And usually when you look at something like this, when you do retirement accounts, it's usually, when I do my agreements, it's about 4 or 5 pages long to discuss how they're going to be divided. Okay, now remember too, when the judge looks at the 4 corners of the documents, if you waive certain things or don't put certain things in the agreement regarding retirement accounts, you're not going to get them. You're not going to get the money. Okay, because look at the 4 corners of the documents and it's not in there how to divide up the retirement accounts. And I had this case with one of my clients. They come in and they lost out on thousands, I should say probably 100,000 or more, because they didn't realize how to write up the proper language, how to divide up a pension. And I got to tell you that, in my opinion, I would say probably 90 to 95% of the attorneys out there have no idea how to write up an agreement regarding retirement accounts. All right. Now, I'll probably get attorneys calling me, ringing the phone off the hook. I've seen it so many times that they call the retirement accounts different things. They put down the wrong way to divide accounts. They don't put information in regarding death benefits and things of that nature. It's very, usually for retirement accounts and pensions, there's attorneys out there that specialize, and that's all they do because that's how complicated they are now. Now, also in separation agreements, you talk about taxes, how you're going to file your taxes, who's going to be responsible for any taxes that might come up after you're divorced, after you sign this agreement, where, say, if somebody 5 years ago, all of a sudden the IRS can back up and you're married to somebody and they say, okay, Mr. and Mrs. Belsky, you're now divorced, that's fine, but back in 2000, whatever, you both signed this tax return. We just did an audit on your tax return and you owe us $50,000. And my wife says, well, wait a second. What do you mean we owe $50,000? You know, I just gave him my W-2 and he sent it off to the tax person, or he did his own taxes like we do every year, you know, and then IRS doesn't care. Okay. You owe it, you both owe it, and you don't owe it 50-50, you owe it joint and severable. That means I can get 50,000 out of you and nothing out of your husband. And they'll go after everybody. So you got to be very careful in agreements. Now, we can't stop the IRS from coming after somebody, but we can put in agreements that specifically set forth that if for any reason, any past tax filings that were filed and there was some discrepancy or some type of fraud, then that party who committed the fraud or the discrepancy will hold the other person harmless. Now, what that means is that doesn't mean that the IRS can say, okay, this is a great agreement, Mrs. Belsky, you don't have to pay nothing. No, what it means is that you're still both jointly and severally liable for it. But then again, as far as then we can go after the person who did the taxes, committed the fraud. Now we talk about also in agreements, how you divide up personal property. Personal property is what I call stuff in the house, you know, furniture, cars, motorcycles, boats, motorcycles, tools. That's what I call, you know, really, that's what kind of personal, you know, antiques, jewelry. That's what I call like the basic of personal property. But also, you know, personal property can also be under the heading of bank accounts,
Stock accounts.
Right.
Yeah.
Things like that. You know, but we always keep them separate. Okay, because you really want to set forth in your documents these specific accounts and who's going to keep them and what's going to happen with them. So we try to keep the personal property separate. We kind of keep the bank accounts so everyone knows exactly what we're doing here. And so that's kind of what we call personal property. Now, funny thing what's going on now is it's coming up a lot. I have a case right now, as a matter of fact, Clark and I do have a case where at this point in time, about 2 years ago, a lot of cases came down regarding pets during the marriage. All right. And regarding pets during the marriage, they're actually personal property. And the thing is, when you're looking at this, it doesn't matter whose name those animals are in or they were purchased during the marriage and lived with both parties. If the parties can't decide what to do with the pets, then you're going to have a trial on the pets. And basically what it looks at is who can take care of the pets better than the other one and who has been the primary caregiver for these pets during the marriage. So that's big now. I have a trial coming up with Clark on this one, but it happens all the time. So that's another thing that you want to put in. You put in clauses during pets. There's also pet visitation that you put in these. Okay. Then we looked at in these issues debts. Right now, there's marital debts, and then there's separate debts. So marital debts, you know, we'll forget about the house because, you know, when you do the house, you have to actually put in there. I'm going to take a step back. Let's talk about the house now. It starts this separate with marital property. You have a house during the marriage. Okay, then we want to go ahead and we're going to separate, and then we're either going to sell it or one person is going to buy the other person out. There's no question we're going to say that this is a marital asset. So say someone wants to buy the other person out. And let's say there's a mortgage and there's a deed, both persons' names. What you do is, the first thing is you have to decide what equity is. What is equity? Equity is you take the value of the house, you get it appraised, and you minus the mortgage, And in the simplistic term, the difference between what you owe and what the value is equity in the house. All right. Now, so somebody's going to buy the other person out. This is a very simplistic because there's a lot of other ways to figure out equity. So one person wants to buy the other person out. Let's say there's $100,000 in equity. So wife and husband are each entitled to $50,000. So the first thing you do is we're going to figure out who keeps the house. We got to figure out whoever's keeping the house, how they're going to pay the other person $50,000. Then we go ahead and we figure out how we're going to get the deed, the name off the deed. You put that in your agreements. And refinancing the mortgage out of the one person's name who's not getting the house into the other person's name. So you put all that in your agreement and you have time frames for this. But the first thing you have to realize when you deal with these things is that can one party, say we have a house which owes $300,000 and there's a mortgage of $200,000. We say, okay, we're gonna let you buy me out. You're gonna give me $50,000. But then the question becomes, the person who's gonna buy the other one out is, can they refinance the house? Lots of times it sounds great that you're gonna split the equity. But then again, if the other person cannot refinance the mortgage, I'm not gonna let my client who's getting bought out of the house stay on a mortgage for, let's say, a couple $100,000, because that will affect his ability, number one, to buy something else. And number two, if the person who's going to buy my client out defaults on the house, I can't go to the, I'm not going to go to the credit bureau and say, look at, geez, she bought me out. They go, I don't care. You're still on the mortgage. You're late just as much as she's late or he's late in paying these payments. So what can you do with that case? You have to set up very strict parameters how long the other party is going to take to buy the other person out. All right. Who's going to be responsible for the payments? Why they're trying to refinance the home. All right. And then you do the same thing if you're going to sell the house. You say in the agreement, you're going to sell the house. You're going to jointly find a real estate broker. You're going to go ahead and you're both going to sign the broker agreement. You'll agree to reduce possibly the listing price after so much time. If there's no takers on that amount of money, you also determine who's going to pay the mortgage and carrying costs in the home, why it's for sale. If one person is out, you're going to put in there that the person in the house will make sure that it's available for showing and they'll keep it clean. Clark and I have had these cases where, one party leaves, the other party stays in the house and there's animals. I've had cases where the one party in the house doesn't want to leave. They leave dog dew all over the place. They keep the house a mess. It's a wreck. It smells. That happens, trust me. So you have to put in the agreement also that the person inside that house will make sure it's kept clean and available for showing. And then how to divide up the money. Now remember, like I said before, if you don't put this in, you're going to get stuck. We had a client that did this on their own, and it says that the husband and wife agrees that the husband's going to move out, and he said, "Well, gee, I'll pay." He said to me, I said in there that I agree, I'll pay the carrying charges and the house until it's sold. And so all they put in there is that, he's going to move out, he's going to pay the carrying charges until it's sold. And then they're going to split equity. Right. So what does that tell you? So if he just signed that off until it's sold, it doesn't say when it has to be sold. It doesn't say when it has to be listed. It doesn't say who has to list it. That's so vague, lots of times the courts eventually will put a parameter on this, but you could be stuck for months and the person who's paying all these expenses could be paying all these expenses. And let's say the wife has exclusive use of the home, she gets to live there. If this goes on for years, okay, it's a lot of money going out to let someone live in that house for free. All right. So those are just things that you really need specific language, how to get things done, and how you're going to get your equitable share of assets. Now, the next thing, very quickly, I'm going to talk about maintenance. Now, there's a maintenance statute in New York State that came out a few years ago, and New York State directed specifically how maintenance should be paid, how much it should be paid based upon the party's incomes, and for how long it should be paid. Now, I and everybody in my firm here, in this firm, specifically sets forth in detail the statute, parties' incomes, what's the statutory presumption of maintenance, how much it should be, and for how long. Now, remember, in a marital settlement agreement, you can do whatever you want. A lot of parties say, I want to waive my maintenance. I don't care. I don't need maintenance, or I don't need that amount of money. I'll take less. I don't need maintenance for that long under the statute. So as long as you spell it out in detail, so when they're reading this agreement, they can see what they're going to get and how much they should get. Then you could, after that, you could say, well, Mike Belsky waives maintenance from his wife, and he's not going to take his maintenance for 5 years. He agrees he'll take it for 1 year, and he's only going to take the half amount that he should get. And then otherwise, he waives the rest. As long as you do that, you spell it out, nothing's going to, the courts are not going to come back and modify that, okay? Even if you waive it and then say you go to court and try to get a divorce, the court's not going to change that. What you have to remember with a separation agreement, everything regarding equitable distribution, debts, assets, retirement accounts, everything in that agreement, once you sign it, that you're going to be bound by that when you go for a divorce. It's not going to change. It's going to be there. You could try to fight it in court, say, well, geez, I should have got maintenance, but I waived it. The court's going to say, too bad, you waived it. Now, what you have to remember is that there's two things that you cannot contract away. Remember, it's a contract, which you're signing. You cannot contract away your rights of your children, and that is custody and child support. Now, what I mean by that is that if you have children and you want to do a separation agreement, we do put in that separation agreement custody, and Clark's going to talk about that, and we do put in child support. Now, again, with child support, you have to be very specific. When you do your agreement, there's statutory language that has to be in the separation settlement agreement or it will not be valid right off the bat. All right. Myself and one of the attorneys here won a case in Rensselaer County, family court, child support, where one of the judges failed to put in the statutory language when directing child support. And we brought it up and courts agreed. And then what happened was that the father of the kid, we represented the mother, basically, he ended up having to pay my client retroactive support for almost 8 years because the agreement that was in place was invalid and void on its face. So you have to be very specific with regards to child support. You have to put in there how much it should be. You have to spell it out in detail. There's actually a chart that you actually put into these agreements, how much each person makes, how much do you take out in FICA taxes, how much is the child support should it be for the child, and then there's a cap, $183,000 cap, which is a whole different hour to talk about. And you have to spell it out in detail. Now, and you spell it out and you say, okay, regarding child support, this is what the person's supposed to pay. Everyone knows, so each person knows what they should get or what they have to pay. And then they go ahead and they sign it, we're fine. Now, the second thing is going to be when they deviate and they say, well, I don't need that amount of money, I'll take less. You have to make sure you put deviation factors in there, and there's certain factors why a person, once they know what they're supposed to get, and they agree to take less, why are they taking less? As long as the person knows who's receiving support, it's spelled out for them in the agreement, based upon the statute, what they're supposed to pay, and they know that, they can see it, and then they deviate from it or take less, and they sign on it, pretty much, if you go into court, all right, that'll then become the court order. All right. Now, when I say the same thing, the custody, Clark will talk about that. This will be in the agreement also, custody. But now remember, you cannot contract away the right for your children in a contract. Now, if you go ahead and the settlement agreement becomes a part of your divorce and you get a judgment of divorce, and the agreement becomes terms and conditions of your divorce, and you have a court order, then the court order is binding. What I'm going to say now about child support. So let's say in this agreement, one of the spouse who has custody of the kids waives child support. Says, I don't want anything. I see that I can get $500 a month. I don't want any money. And then, a year later or 6 months later, they go, well, gee, I want support. I need support for my child. And so they come to me, I file for child support, and let's just say Saratoga County Family Court, and I go in front of the support magistrate, and I file a petition for child support, and I say to the judge, my client wants child support based upon the Child Support Standards Act. We believe that she should get this money. Now, the other party says, with their attorney, the attorney goes, well, wait a second, Mr. Support Magistrate, I've got this agreement right here in my hand, and it says that she doesn't want any support. So based upon this signed contract, this agreement, now we know it's not a court order yet. There's no judgment of divorce, but based upon this, she waived it, so she doesn't get it. Well, then remember, then the support magistrate is going to say to the other attorney, sit down, you don't know what you're talking about, Mr. Belsky, proceed. This person is getting child support. Remember, you can't contract away your child's right to get support. Once it becomes a court order, it's a whole different, once it's divorce in a court order, it's a whole different ballgame how you modify child support or these calculations in a marital settlement agreement. But until you get actually a court order, child support and custody, you cannot contract away. Now, I've probably been talking long enough. I'm going to turn it over to Clark now. We're going to talk about custody in settlement agreements.
Sure. Thanks, Mike.
Sure.
So, child custody, when we talk about child custody and marital separation agreements, first we need to understand that there are two different types of custody that we're talking about. Legal custody and physical or residential custody. Now, legal custody is exactly what you think it is. Who gets to make decisions about the welfare of the child, about religion, about where they go to school, medical decisions? Is there an obligation for both parties to be involved in that decision making? Does one party have final decision making over the other? Or do both parties just have mutual power? Those are the type of legal custody arrangements that you can have depending on the relationship that exists with the child, the relationship between the parents and their cooperation. You can have joint legal, you can have a 50-50 split of legal, or you can have legal custody where one parent has primary decision-making power, which means they still have to consult the other parent, but they have the power to make the final decision over the other parent. Some of the variations in what kind of legal custody arrangement you would have with your partner depend on questions of physical custody. Who has the primary residential custody? Is there some other reason beyond just the party's position physically in conjunction with the child to where you would want one party to be able to make the final decision? For instance, if dad's going to live, let's say dad's going to live in Florida, and mom has the children in New York, does it make more sense for mom to have the ability to have final decision making in matters of legal custody over father? Those are the type of things that you can negotiate and you can come to agreements on in regards to legal custody. Then we get to residential custody. And residential custody in the state of New York is very funny in the sense, one, you need to be aware if one of the parents is leaving the state of New York and the child is at home in the state of New York family courts, on balance, tend to prefer for the child to stay in New York and for that to be their primary residence. So keep that in mind. I have plenty of cases where I have military parents, one parent may be returning from tour and now they're going to live in a different state. I have cases where parents have just decided for one reason or another, they're going to go to Pennsylvania or they're going to start a new life in New Jersey. And we have to have tough conversations about what the ramifications of that are for physical custody. Of course, when I talk about physical custody or residential custody, a lot of clients out the gate say, I want 50-50 custody. Absolutely, right? Who wouldn't want to spend time with their children? But keep in mind, as you are negotiating in the marital separation agreements, right, we have a 7-day week. 50-50 is really hard to do with 7 days in a week. That's an odd number. Also, parents have to think about things like school. They have to think about summer breaks, winter breaks, spring breaks. All of these things are taken into account when we're talking about how you set up the residential status and physical custody of the child in a marital separation agreement. Once again, just because you say there's going to be split physical custody or 50-50 shared physical custody, that still requires that you actually create a visitation schedule in the agreement. So we'll need to know if the child is going to stay with mom 4 days out of the week, or let's say 3.5, go to school on the third day, and that's where the transfer happens after school, then that needs to be specified. The child will be with mom from Sunday evening until Wednesday morning with drop off at school. And then the child will be with father from pickup at the end of school until Sunday evening. You'd actually need to specify that time. You would need to specify the specific location and time of pickup. But as Mr. Belsky knows, as I know, part of the specificity that's required in a marital separation agreement when it comes to custody specifically depends on the relationship between the parties. So it is possible if the parties have no ability to interact with each other, no ability to talk about the child without fighting. Okay, that section of the custody section of the separation agreement probably is going to have to be very specific, very laid out and detailed about things so that one party can't deviate without the other party having some source of correction already written into the separation agreement. And hopefully that separation agreement is taken to court and becomes a court order that can be enforced. The other thing you have to think about when we're talking about child custody for separation agreements are holiday schedules. A lot of people think about Christmas. A lot of people think about Thanksgiving. There are a lot of holidays out there. There's parental birthdays, which are treated often like holidays. There's a child's birthday. So oftentimes, beyond the provision that we create for physical custody and visitation, beyond that provision, there are additional provisions that we'll put into the child custody section that specify a holiday schedule based off of, again, what the parties agree to. And that holiday schedule, I don't want anyone to think it has to be, a lot of attorneys use the parties will alternate Christmas and Thanksgiving. So one parent has Thanksgiving, one parent has Christmas, and then you flip it the next year. That is certainly a structure that the courts use. It's a simple structure. It's a structure that the courts like. However, again, this is a separation agreement. And as Mr. Belsky's pointed out several times, you can agree to any structure that works for you and your family. So if for you and your family, you're in a position of where mom can have the child in the morning on Christmas and dad can have the child in the evening on Christmas, you can agree to that as long as you specify that in the separation agreement. Similarly, if dad's family typically opens up Christmas gifts on Christmas Eve, mom's family does Christmas morning, again, you can agree to that. Okay? You can agree to that in the separation agreement. That's completely up to the parties to come to that agreement and then specify that language in the separation agreement. Because again, the separation agreement is a contract. In order for it to become a custody order, you have to go to a judge in order for them to turn that contract into an order. Just to quickly hit, because I want to leave us time to answer some questions. We did get some pre-webinar questions, and then we've gotten an extra one during the webinar. Just to hit on a few other provisions that you want to be thinking about for the custody section of a marital separation agreement. Access to medical and school records. I can't tell you how many times we have cases where we have parents that there's no reason for them not to have joint legal custody. So the court gives them joint legal custody. And yet one of the biggest complaints we get is, well, I still don't have access to their school records. I still don't have access to their doctor's records. Those are the type of things you want to preemptively specify in the marital separation agreement. So that way there is an obligation on both parties to make that information available. Or, for instance, insurance cards. That's one I often run into, where one parent, typically the non-custodial parent, doesn't have the insurance card that the custodial parent, the parent with primary residential custody, is using. Okay, well, that's something that, again, we now have to go back and we have to ask for and we have to go through a process in order to get that we otherwise wouldn't have to go through if there had been more specification in the marital separation agreement, child custody section. Another point just to mention, disparaging comments, right? A lot of times when people are going through, as you can imagine, at the point you're making a marital separation agreement, I mean, again, you and your spouse, soon to be ex-spouse, you may be on good terms, you may not be, you may just be trying to get through it for the kids, right? When these agreements become divorces, when these agreements do become court orders, it's going to be important for you to try and anticipate sources of future conflict that could happen. And one of the biggest sources of future conflict that the courts, I mean, I haven't run into a family court that won't throw in a non-disparaging clause. It's disparaging. Is one parent talking badly about the other parent in front of the child? Courts do not like that. Courts do not want children unnecessarily burdened with the litigation process. They don't like that as well. But they don't like the idea that one parent, either through themselves or through family, is allowing people to put down another parent when that parent's absent. So non-disparagement clauses are another section that you would, again, you'd want to throw that clause in the child custody section because once this becomes a court order, that's not the type of thing you want to have to go back to family court or you want to have to go back to Supreme Court in order to try and get thrown in there at the last minute. Finally, modification of the custody provisions. Again, in order to modify the custody provision, in order for you want to throw in a clause in there about modification, about the proper way to modify, but essentially for child custody, I can't repeat it enough, that section needs to be turned into a court order for it to have the full force of law. And you would modify that through the court. If you're doing a modification within 3 years, you file a modification petition, you're going to need a substantial change in circumstance. I could go into more detail about a substantial change in circumstance, but I know we have an upcoming CLE on modification, so I don't want to spoil anything. But essentially, right, with child custody, it is on you as the parties to try and anticipate not just the immediate needs of the child, but what's this child going to need for the future? It's really hard to do even as a lawyer when you're dealing with a child that's an infant, because infants are hard to plan for. Where are you going to be in 5 years? But especially with older kids, you try and create a structure that has enough flexibility, has enough anticipatory clauses in it to try and avoid sources of conflict between you and your soon-to-be ex-partner, while also taking into account what hopefully is in the best interest of the child.
Just, I want to touch on one quick thing. Remember, like I said earlier, custody provisions in a separation agreement are not binding on a court. They can be modified. You can ask for them to be modified. So you cannot violate someone in family court or Supreme Court for not following what's in this agreement. Like Clark said, hopefully everyone gets along, both parties abide by this, but you can't go to court and violate somebody. So if it's not working, like Clark said, your next step is you need a court order. You're going to either have to go to family court to get a court order, or go file for divorce and try to implement what's in the marital separation settlement agreement, because you cannot contract away the rights to the children. One quick thing is, say everything is going great in the agreement and everyone's abiding by the agreement, and then you file for divorce and the other person says, well, I don't like this agreement, I want to modify it. And then the court's going to really look at the agreement and say, what is it? You both have been doing this, it's both been going great, been doing this for like 2 years. Now you want to change this and change custody just because? Lots of times the court's not going to let that happen. But remember that, okay? All right, questions?
Yeah, Mike, let me do some quick fire questions
Yeah.
that we have. I'm going to start with simple ones so that we can try and get through them all. Somebody asked, does veteran status affect a separation and custody agreement?
Veteran, no.
So-
No, it doesn't affect the custody agreement whatsoever. You know, as long as, you know, the question should be though, a veteran status, you know, and there's all sorts of things that you might have. Is there any type of disabilities, any type of basis where you can't take care of the child? Those type of things, you know, they shouldn't, but then again, it depends on what that is, and it's really a case-by-case basis, so it's kind of hard to answer. But
Right.
being a veteran in itself, not at all.
I've got two questions here kind of connected. A common clause in separation agreement is that one party withdraws appearances to permit the other party to obtain a judgment, a divorce judgment by default. Essentially, they're talking about
Yep.
the waiver.
Yep.
Somebody wants to know, what's the purpose of this?
Well, the purpose of that is basically so the other party does not have to sign a waiver and consent. So what if you put that into a separation agreement, then the other party that they're say I'm taking a divorce against my spouse, okay, and then I put it into and there's nothing in the clause that says, there's no clause in there, but my spouse says, yeah, we agree, you take the divorce, go ahead. What the court's going to want to see from my spouse is what's called a consent and waiver. And we do that all the time.
Mhm.
It's a waiver of consent, that you got to serve the affidavit, you consent that the divorce go forward. And the only terms and conditions would be what are the terms and conditions of your separation agreement. It just takes one step out of the process.
Another question about a clause in separation agreement. Well, it's really not in the separation agreement. It's actually when they issue the divorce order, but they're talking about the separation agreement. They often put the language, the separation agreement shall be incorporated but not merged within the divorce judgment. Somebody wants to know, what's the purpose of that?
Sure. Incorporated but not merged. So if it's incorporated but not merged, two things. You can either say someone violates a provision of the agreement. You can either incorporated but not merged means it stands as a contract and it stands as a court order. So you have two ways to attack someone violating that agreement. You could sue them in Supreme Court under contract theory, or you can sue them because they violated a court order and ask the court to go ahead and have that individual go ahead and comply. So that's what it means. There are two separate agreements. You stay in the contract and then you have a court order.
Okay, and then one last one, which I know you like this one. What are common mistakes on the receiving end of a separation agreement when you believe there is hope for reconciliation?
Now, remember that once you sign that agreement, it's binding on both parties. And now under New York State law, for a party to get a divorce, all they have to say is that the marriage is broken down for a period of 6 months, and there's no way that we're gonna be able to reconcile. So once you've signed that, the other party can just sit there the very next day and say, Mike, okay, we signed it, file for divorce right away. You're not gonna fight it.
Okay.
That's the bottom line.
Well, thanks everyone for coming to the webinar. Brittany, is there anything else you need from us?
I'm just gonna wait out a few more seconds to see if there's any last minute questions that come through. So just give me one more minute and let anybody who has any last minute questions come through.
I did see there was one final question, and Mike, I know we know the answer to this. Somebody did ask earlier, can a settlement agreement be done prior to submission of an uncontested divorce?
Almost definitely. And I'll tell you right now,
Recommend it.
I recommend that wholeheartedly. Everyone that I do a consult with, when I talk to them, I ask them, is your spouse someone that we could discuss a settlement with? And if they get an attorney, we can work this out. And if they say yes, then I recommend that they go ahead, get a separation agreement, talk about trying to get a separation agreement. It's far less expensive. It's far less litigious. And as far as now, once you file for divorce, can you still work something out? Sure you can.
Yeah.
But then again, you save money. When I was talking to my clients, I say, listen, instead of paying us $10,000, don't you think it's better to put it for your kid's education somewhere if we can work something out, not have to do all this litigious stuff? And that's what I say. If we can work it out, we should work it out.
All right, well, it doesn't look like there's any more questions. So I want to thank everybody for joining today's webinar, and thank you, Michael and Christopher, for presenting. Today's presentation was recorded and a copy will be sent to all attendees later this week. I hope you all have the great rest of your week. Thank you. Bye.
Thank you, everyone.